In the winter of 1931, a county land surveyor named Harlan Dewey Marsh walked into a Pennsylvania courthouse in Luzerne County, clutching a document that had not been referenced in any official proceeding for 63 years. He had found it inside a sealed deed box, iron-latched, paper-wrapped, tucked behind a collapsed shelving unit in the basement of the original clerk's office. The box contained 11 handwritten pages, a notarized affidavit, and a surveyor's plat that showed property boundary lines most of Wilkes-Barre still lives inside today. The pages referenced a statute so bluntly written that Marsh stopped reading 3 lines in. He marked the page with his thumb. He sat down on a crate. When he came back up the basement stairs 11 minutes later, his assistant later recalled, the color had not entirely returned to his face. What Marsh had found was a property restriction clause attached to nearly every land grant issued in northeastern Pennsylvania between 1862 and 1897. The clause was not a footnote. It ran to 2 full pages. It stated, without euphemism, that land conveyed under the grants could not be legally held, transferred, inherited, or mortgaged by any person whose father or grandfather had been classified as a wage laborer in a company-controlled municipality. The clause had a specific name in internal company records, the heritable encumbrance provision. Marsh took the document to his supervisor. Within 4 days, he was reassigned to a district survey project 40 miles south. The document was not logged in the clerk's intake registry, and for the next 22 years, no one spoke about it publicly. Before we go further, if you find investigations like this as fascinating as I do, hit subscribe so the next one finds you when it drops. The algorithm tends to bury this kind of research unless you tell it otherwise. To understand what Harlan Marsh found in that basement, we have to go back, not just a few years, not even a generation. We have to go back to a world that operated under rules of property and inheritance that most Americans today have never been taught to look for. Between 1860 and 1910, the United States saw the largest internal migration in its history outside of wartime. Millions of workers flooded into industrial zones, coal country in Pennsylvania, Ohio, and West Virginia, textile corridors in the Carolina Piedmont, rail construction camps stretching from St. Louis to Sacramento. The official historical account says these workers were paid wages, lived in boarding houses, and gradually accumulated savings that they turned into land and legacy. That account is not entirely false, but it is incomplete in ways that matter enormously. What it omits is the structure underneath those wages. It omits what the wages were attached to, and it omits, almost entirely, the legal architecture that sat between a working man's savings and the land those savings were supposed to buy. The company town was not an informal arrangement. It was a legal system. Between 1865 and 1905, an estimated 1,500 to 2,400 incorporated municipalities across the United States were effectively owned, not managed, not influenced, but owned by single industrial corporations. The Lehigh Valley Coal Company controlled 11 municipalities in Pennsylvania. The Baldwin Felts Coal and Coke Company held deed and governance authority over a corridor of 8 towns in West Virginia that housed nearly 28,000 people by 1890. Within those towns, workers were paid in company scrip, housed in company buildings, and governed under company written ordinances. That part of the record is documented and discussed. What is less discussed is what happened when those workers tried to leave. Everett Callum Haynes was not a radical. He was a church deacon, a father of 4, and a 22-year veteran of the Consol Energy forerunner, known as the Consolidated Coal Company of Virginia. In April of 1893, Haynes filed a land deed with the Buchanan County Clerk's Office in Virginia, intending to purchase 6. 4 acres of unincorporated land adjacent to the town limits of Grundy. The land cost him $140, which he had saved over 7 years. He had cash money, a legal deed of sale, and a notarized seller agreement. The purchase should have taken one afternoon. Instead, the county clerk placed a hold on the transaction, citing what he described as an outstanding encumbrance notation in Haynes's prior company residency file. Haynes asked to see the encumbrance document. He was told it was held in company records, not county records. When he retained a lawyer, a Bristol-trained attorney named George Fisk Lowndes, and filed a formal request for the document, the Consolidated Coal Company's legal representative appeared in the clerk's office within 11 days. Lowndes filed his account of the meeting in a letter to the Virginia State Bar Association in September of 1893. The letter is 7 pages. It still exists in the Virginia State Bar's archival collection at Richmond. In that letter, Lowndes described being shown a printed clause attached to the original deed through which Haynes's housing parcel had been originally assigned. A clause that stated that any person who had resided within a company, designated labor district for more than 5 consecutive years, and whose labor classification was listed as semi-skilled or unskilled was subject to a heritable use restriction on all real property filings within a 40-mile radius of the company boundary. The restriction ran to the filing party's children and, in some versions Lowndes had encountered before, to the grandchildren. Lowndes called it, in his own words, a generational bar on accumulation. He had seen it before. Before Harlan Marsh found that iron box in Luzerne County, and before George Fisk Lowndes wrote that letter to the Virginia State Bar. A German-trained land law scholar named Friedrich Anton Wehrle had documented nearly 80 instances of the same clause across 5 states. Wehrle was not an activist. He was a professor at the Western Pennsylvania School of Law who had spent the better part of 3 decades examining the legal frameworks that governed property transfer in industrial regions. In 1908, he completed a 340-page study titled Encumbered Descent, Labor Classification and the Suppression of Rural Homesteading, 1860-1905. The study contained photographic plates of 11 original documents. It named 23 companies. It listed specific county clerk offices where the encumbrance filings could be verified. Wehrle submitted the manuscript to 3 university presses in 1909. All 3 declined. 1. The editor of a major Eastern academic press whose identity Wehrle did not record sent back a 1-line response. The note said only that the subject matter was outside the editorial scope of their current publishing commitments. The second press did not respond in writing at all. A colleague of Wehrle's later reported that the press's editorial director had telephoned and suggested, in friendly terms, that the manuscript covered ground that was better left to legal proceedings rather than academic publication. The third press acknowledged receipt of the manuscript, held it for 7 months, and returned it without comment. The Carnegie Institute of Technology, where Wehrle held a part-time lectureship, did not renew his position in the fall of 1909. He died in Pittsburgh in 1914. He was 67 years old. He had no prior history of cardiac illness. He had been corresponding with 2 journalists about the manuscript as recently as 3 weeks before his death. The manuscript was not published. A single surviving copy exists, or existed, in the collection of the University of Pittsburgh's Special Collections Division. When a graduate student attempted to locate it in 2006, the catalog entry existed, but the physical document was listed as missing. Location unknown. No removal record on file. Now let us look at the pattern. Buchanan County, Virginia, 1893. Everett Haynes's land purchase blocked under a clause held in company records, not public records. Luzerne County, Pennsylvania, 1871. A surviving deed record from the Lehigh Valley Coal Company archive includes a 2-page rider attached to every labor housing grant issued between 1869 and 1884, restricting property acquisition within the designated district for any holder classified as common or contract labor. Kanawha County, West Virginia, 1898, a circuit court case, Alderman v. Chesapeake and Ohio Land Trust, resulted in a judgment denying a worker's property claim on the grounds of what the presiding judge described as a prior encumbrance of record. The ruling cited a company-held instrument that no opposing counsel was permitted to examine in full. Raleigh County, West Virginia, 1902. A county surveyor named James Bolin Pritchard filed a formal complaint with the state legislature's Land Records Committee after discovering that 140 separate residential assignments within the Beckley Coal District contained identical restriction language. His complaint was tabled. It was never brought to the floor for a vote. Pritchard was transferred to a state road survey project in the Eastern Panhandle 6 weeks later. Lancaster County, Pennsylvania, 1888. A Mennonite farmer named Abram Schenck attempted to purchase a 12-acre parcel from a textile mill operator in Conestoga Township. The deed was held pending a review of Schenck's prior employment classification. He had worked for 3 years inside a mill-adjacent labor camp before establishing his farm tenancy. The review took 8 months. When it concluded, the purchase was permitted, but only under a use restriction that prohibited Schenck from subdividing or bequeathing more than half the parcel to any single heir. He never understood the legal basis for that condition. His grandson, interviewed by a local historical society in 1967, said he had never understood it either, and that the restriction had shaped every property decision their family made for 70 years. This is not coincidence. This is a pattern. The economics of the restriction are not difficult to understand. A worker who cannot own land cannot accumulate equity. A worker who cannot accumulate equity cannot leave. A worker who cannot leave remains a controlled labor unit for the duration of his productive years and, under the generational extension of the clause, his children remain the same. His children grow up in a rented house, in a company town, with no deed to their name, and no understanding of why that is. Only a vague family memory of a purchase that never went through. A paperwork problem that was never properly explained. The restriction did not need to be enforced with violence. It operated through paperwork. It operated through the transaction that didn't close. The deed that came back with a hold notation. The clerk who said come back next month, and next month after that. George Fisk Lowndes tried to bring the Virginia case to the State Attorney General's office in 1894. He was told the matter was a private contractual dispute. He filed a legislative petition in 1896. It was assigned to a subcommittee that did not meet. He wrote about the Haynes case in a legal journal in 1898. The journal's editor added a note below the article saying that the claims had not been independently verified and that the journal did not endorse the characterization of the instruments described. Lowndes retired from practice in 1911. In an interview with a Roanoke newspaper recorded in the fall of that year, he was asked what he considered the most significant legal matter of his career. He named the Haynes case without hesitation. He said, and this is paraphrased from the printed transcript, that he had spent 17 years trying to get one government body to acknowledge that the documents existed, and that every time he had come close, the documents themselves had found a way to become unavailable. The interviewer moved on to another question. Here is what the official record has never adequately explained. It is never explained why the Virginia Attorney General's office received Lowndes' petition in 1896 and did not assign it to any investigative officer. despite the petition naming 14 specific companies and providing the county and date of each encumbrance filing. It is never explained why Friedrich Werle's 340-page manuscript, which cited primary source documents held in public county clerk offices, was declined by 3 university presses in the same calendar year, without any documented explanation beyond editorial scope. It is never explained why the Luzerne County deed records for the period between 1869 and 1884, the exact period covered by the Lehigh Valley Coal Company's labor housing grants, are missing from the publicly accessible collection, while records from the years immediately before and after that window are complete. Why would 3 separate university presses decline a documented legal study in the same year unless something more than academic taste was at work? Why would a county clerk's restriction instrument be held in company records rather than in the public deed registry, where every other encumbrance in American property law is legally required to be filed? Why would a man who had saved for 7 years, obtained a legal deed of sale, and retained a licensed attorney still be unable to close a land purchase in 1893, unless the instrument preventing him from doing so was designed specifically to be unanswerable? These questions do not go away because institutions refuse to answer them. For the next 14 years after the Roanoke interview, Lowndes continued writing. He maintained a private correspondence with Harlan Marsh's uncle, a fact Marsh himself disclosed in a 1953 letter to a Pennsylvania Historical Society, and he had assembled, by his own account, transcripts from 11 separate cases in 5 states, all showing the same restriction language, all involving workers whose land claims had been blocked under instruments held outside the public record system. Lowndes died in the spring of 1925. The official cause was listed as natural causes. He was 74. His private papers, the case transcripts, the correspondence, the assembled documentation of 17 years of investigation were never transferred to any public archive. His family reported that the papers were taken by a representative of one of the coal companies under what legal authority they did not know, within 3 weeks of his death. When Harlan Marsh came up those basement stairs in the winter of 1931, he did not yet know any of this. He knew only what was in the iron box, and what was in the iron box was a deed restriction that applied to the land his own grandfather had tried and failed to purchase in 1877. His grandfather had been told there was a paperwork problem. He had waited 2 years. He had made 3 separate trips to the clerk's office and been turned away each time with a different explanation. Once told the title search was incomplete. Once told there was a competing claim under review. Once told the surveyor's plat needed recertification. The land was eventually sold to a company-affiliated buyer at a price lower than what his grandfather had offered in cash. The house Marsh himself grew up in was a rental. His father had grown up in a rental before that. Neither of them ever owned the ground they stood on. Neither of them ever knew why a paperwork problem from 1877 had followed their family into the 20th century. Marsh held those 11 pages for the rest of his working life. When he retired in 1958, he gave a single copy to a cousin in Scranton and told him to keep it somewhere safe. Whether that copy still exists, no one has been able to confirm. The heritable encumbrance provision was never formally repealed. There is no repeal on record because there was never a statute on the books. Only private instruments, filed in company offices, enforced through the quiet compliance of county clerks, and the even quieter disinterest of the offices that were supposed to protect against exactly this kind of arrangement. There are property law scholars today who argue that remnants of these instruments may still technically exist as attached encumbrances on certain parcels in coal and textile districts, unenforced, but never voided, buried in the chain of title the same way the original documents were buried in that iron box. The box Marsh found is not in the Luzerne County Archive. It is not in any publicly listed collection. What became of it after his reassignment, no record says. The official history tells us that workers in industrial America built wealth slowly through hard work and saved wages, that the path from labor to land was open to anyone willing to be patient and frugal. What the documents tell us is that for hundreds of thousands of those workers, the mechanism for converting labor into land, the one transaction that makes savings permanent and heritable, was quietly, legally, and systematically blocked at the moment they tried to use it. Not in one state, not by one company, across 5 states, across 40 years, using nearly identical language, filed in company offices rather than public registries, enforced by clerks who knew better than to ask who had written the clause. The restriction did not announce itself. It did not require violence or confrontation, or a single moment of obvious injustice that a man could point to and name. It operated through the deed that never closed, and the document no one was permitted to read. If you have made it this far, you already know that buried records do not disappear because institutions ignore them. They disappear when no one looks for them. Subscribe and share this with someone who needs to hear it. History does not die in a basement. It dies when no one bothers to go down the stairs. Next week, I am pulling a thread that connects the heritable encumbrance provision to a set of land trust instruments filed in 4 southern states between 1905 and 1921. Instruments that use the identical restriction language, applied to a different population entirely. A lawyer named Thaddeus Price Moorfield spent 9 years trying to get one of them thrown out. I'll tell you what happened to him.